That takes us to SB354.
Thanks, Chair. SB354 relates to Justices of the Peace. This is a bill brought by the Chair that was heard here on March 31st. It requires the Justice of the Peace to have received a passing score on the Multistate Professional Responsibility Examination unless the National Conference of Bar Examiners prohibits the Justice of Peace from registering for and taking the exam. The Chair has proposed an amendment in consultation with the Administrative Office of the Courts. That amendment is attached. It strikes the original requirement concerning the multi-state professional responsibility examination and instead adds the following language. I can read that, Chair, or we can just move on if you want to.
That's okay. Thank you, Mr. Guinan. I hope all of you are looking at the work session document. There is an amendment attached. Basically, what the amendment says is that the Judiciary will develop a test for for Justices of the Peace to take and pass within 18 months of being appointed or elected to that position. And we can read it out loud if you'd like. Are there questions about the amendment? I did talk to the Judiciary about it, and the Supreme Court and the judges of limited jurisdiction, I believe, are in support. They're nodding at me from the back. Sorry, Senator Hansen.
Just a quick question. I think the amendment may have cleared it up. The question is, you get Justice of the Peace runs for office. After they're elected, they have to take this. If they fail, your amendment gives them 18 months to clean that up? Or, I mean, what happens if you fail after you've been elected by the people to be a JP?
The way that the amendment is drafted, if you failed that exam and it was less than 18 months, you'd have an opportunity to take it again. If you were unable to pass it within 18 months, then you would not be eligible to take office. And so that seat would end up vacated and you have to go through the same appointment process.
Okay. Makes sense. I was just trying to wonder what happens if you can't pass the test. So that's the answer. Thank you.
And just to, by way of clarification, the amendment was drafted so that this could either be a freestanding test or it could be incorporated into the Judicial College as a kind of final examination, which I think is the direction that the stakeholders plan to go with this, but we wanted to leave it open so that whatever makes sense when we start to develop when people smarter than me start to develop the test, determine it makes sense. Senator Stone.
Thank you, Madam Chair. Could you just maybe articulate is there any direction as to what the format of the test is going to encompass? Judicial ethics, judicial procedures, basically making sure that somebody has a solid foundation to be a judge, I presume?
Yes, excellent question. The amendment doesn't prescribe the format of the test in terms of whether it be essays or multiple choice, but it does prescribe that it would have to include judicial decorum, civil and criminal procedure as relevant to their jurisdiction, orders of protection, and accounting standards for attorneys who would be appearing in front of them. Any other questions? Yeah, Senator Harris.
Thank you, Chair. Is there any guidance in the bill as amended as to what the standard should be for the cutoff score? Or is there some risk that, they may decide you just need a 50% to pass? Just a thought.
So it does not prescribe. Part of developing the test would include developing what a passing score would be. All right. If there are no other questions, I would accept a motion to amend and do pass. I have a motion from Vice Chair Harris, a second from Senator Orenshaw. Any discussion on the motion? All right. All in favor, aye. Aye. Any opposed? All right. This passes unanimously, and I will take the floor statement. That takes us to SB 401.
Thanks, Chair. SB 401